to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. I'm here with Ann Lipton, law professor at Tulane in New Orleans, who teaches and researches securities and business law. She stands by and holds up the legal end of this podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
This week, we have two fun subjects. First, we'll talk about a recent ruling in the Fifth Circuit on the so-called Nasdaq diversity rules related to diversity on boards of directors and what happened and what it means for corporations and corporate law in the world at large.
And we'll also take a look at the lesser-known side of proxy advisors ISS and Glass Lewis and how they consult with corporations.
Yes, we will. Let's first tackle these Nasdaq diversity rules. And I think there's sort of like an immediate kind of case that or set of decisions that happened that are be interested to activists who want diverse boards. But then there's some broader implications for it, if I understand correctly. So what let's kick this off and sort of figure out, what exactly were the rules that was at question here.
Okay, yeah. So Nasdaq adopted these board diversity rules, and the rules said every listed company had to disclose the race and gender makeup of the board, and every board also had to have at least one woman and one person who identified either as an underrepresented racial minority or as LGBTQ. And for smaller boards, you could have just one. But for
one of those two.
One of those two.
You pick.
Yeah. And for a larger board, you had to have like at least two. And if you didn't meet the requirement, you had to explain why you couldn't meet it. That's called a comply or explain rule. You do what they say, add a woman and person of color to the board, or explain why you didn't. And I'll just say Bloomberg actually ran a story while the rule was in effect on the explanations. And they were, hilarious. Like a casino company said it had trouble finding candidates who were willing to subject themselves to the rigorous and intrusive process necessary to obtain a gaming license.
Oh, gaming licenses.
Yeah, that's why they couldn't have women on their boards. That's why they couldn't have people of color on their boards.
That happened to me. I was on a board where I needed gaming licenses. And I know it's kind of interesting. It is a hassle. These gaming licensing boards and agencies are tough.
Well, I am glad to hear it, but I'm not sure I buy it as an explanation for why your ball has
great.
Yes,
no, it's just you just got to find someone who's willing to do it. Okay.
So anyway, but that was the rule. You had to have two directors who weren't white straight men, or you had to explain yourself. Now, to be clear, the Nasdaq Stock Exchange, it's a private company. Its corporate owner is actually publicly traded, but because the Nasdaq is a stock exchange, even though it's a private company, it's also overseen by the SEC. So to get these rules passed, it had to petition the SEC and take public comments, and then it amended the rules. And ultimately, the SEC approved this set of rules.
So just to so this is only Nasdaq companies. This is not IC companies. So it's all the smaller, newer tech kind of companies, which presumably they'd be at least a little interested, maybe not, in more diverse boards. And and this was a requirement to keep your listing that you either comply with having these two diverse candidates, diverse directors, or explain why not.
Exactly.
To keep your listing to continue to be traded and not move to the pink sheets and so forth. Okay, cool. Yeah. So and the SEC blessed this, all listing, like NYSE, Nasdaq, the SEC oversees all their listing rules.
Exactly.
Okay, go ahead.
Well, I mean, the really interesting question is sort of like, well, why adopt these rules, right? I mean, now the answer, like that Nasdaq would say, is they adopted them because investors wanted them. They claim investors wanted more information on board diversity and investors wanted more diverse boards. And when I say investors, I mean like institutional investors, BlackRock, Vanguard, State Street. So that leads to the question, like, why do large institutional investors want
why do they even care?
Why do they care? And there are a couple of different answers, and you can take your pick. So one story is it's wealth maximizing. It is better for companies, it is better for profits if boards are diverse. Why? Maybe they can absorb more complex information. Maybe they challenge each other's ideas, or they identify new markets. Whatever your story is, one strand of thought is diverse boards do better. But there's another story, which is That's not true. The evidence,
right, and the evidence is, I will say, I've read some of the analysis, the evidence is mixed at
it's
best.
mixed, it's weak, it's contradictory. And so then, well, why are they asking? And so some would say that the real reason large investors want diverse boards and why Nasdaq wants them is they're woke.
Right, yeah, this is just a way to express
corporate America are actually a great force for woke liberalness for the rest of America. That's another story. Now, I personally do not think the titans of finance in America are particularly woke.
No, I probably agree with you.
But I actually think it's something a little different. I do think it's wealth maximizing, or it's wealth maximizing for asset managers to ask for them. But the reason isn't like this direct idea that racial and gender diversity necessarily contributes to better decision making. I think it just looks better when the massive public companies make some gesture towards being inclusive. Like, I mean,
sure.
I'm really sorry. We are living in a world where someone murdered the CEO of United Health, and he's being hailed online as a hero.
Oh, the murderer is being praised by,
exactly.
I mean, kind of widely,
world,
yes.
Where so many people are so angry at the sheer power exerted by large corporations, it maybe diffuses some of that anger if corporations make an effort to at least appear.
At least a gesture, at least a pretense.
Exactly, that all decisions aren't made by some kind of good old boy network. So
a bunch of, as you say, straight white men. Exactly.
So I think that is the real purpose of the rule.
All right. So NASDAQ promoted this for these reasons.
Whatever. They say because investors want them.
Right. And then the SEC, which is their job, said this is kosher.
Yes, exactly.
To have these rules. But then somebody challenged the listing rules in court.
Right. Yes.
So how'd that work?
Yeah. So immediately after the SEC approved the rules, a couple of conservative organizations filed a legal challenge. One was the National Center for Public Policy Research, and the other was
them.
Yeah, they do this all the time. And another organization was called the Alliance for Fair Board Recruitment, which, as far as I can tell, was created for the purpose of challenging these rules. And procedurally,
specifically like a single. I've heard. I know. I invest in SPVs, single purpose. Single purpose vehicles. This is a single purpose lobbying organization.
Yeah, I mean, I think they also
single purpose
California
plaintiff
adopted rules like this. They may have also been in the mix, but I think they were created for this purpose. They saw this rule coming, and they were created for this. I think. I mean, they're very new, and we don't know much about them. And I think they were created about the time the rules went. And the name Alliance for Fair Board Recruitment. I mean, this wasn't
sort of tells it all.
So they could petition to an appellate court to challenge the rules, and of course they chose to petition to the Fifth Circuit. They chose the Fifth Circuit for obvious reasons. The Fifth Circuit is dominated by very conservative judges who are also very aggressive about striking down Democratic initiatives. But by pure luck, they happened to draw a panel of Democratic appointees. You get a panel of 3, and by luck, they actually got 3 Democrats. And that panel upheld...
Or democratically approved justice, appointed judges.
They were appointed by Democratic presidents. Yeah. And that panel upheld the rule. But then, after this panel upheld the rule, the full court, all the judges, they agreed to rehear the case because obviously they didn't like the fact that this panel of Democratic appointees said the rule was okay. So,
and that's called en banc.
En banc.
En banc. En banc.
You could say it either way.
En banc.
So all the judges agreed to rehear the case, and when they reheard it, they voted to strike it down 9-8. So it was actually really close because a couple of the conservatives actually voted with the Democrats. So that is why.
Okay, so now what was the court's reasoning? Yeah. And the en banc. What was the majority's reasoning for rejecting these?
Okay, so the court held that these rules went beyond the actual purposes of the Securities Exchange Act. And since the SEC can only approve rules that are consistent with the Exchange Act, by approving this rule, the SEC exceeded its authority. And to get there, the Fifth Circuit had to start by analyzing, well, what are the fundamental purposes of the Exchange Act? I mean, if this rule is going to be inconsistent with the fundamental purposes of the Exchange Act, well, what are those purposes? Its view is that the Exchange Act only has a few really basic purposes. It's there to prevent speculative bubbles, it's there to prevent fraud, and it's there to ensure that there's sort of efficiency and competition in the execution of securities trades. That's all.
That's pretty narrow. So
that is really narrow. That's really narrow.
3 purposes.
Yeah, competition and securities trading.
In your order, prevent bubbles.
Prevent bubbles, excessive
prevent
speculation.
Fraud. And then
like just the
what was the third?
mechanics of securities trading to make sure that that goes properly.
Oh,
and there's
that
competition
when
among-
I send my orders in a day that they're getting best
Exactly.
execution, it's called.
Exactly, that kind of
Okay.
thing. So in the court's view, information about board diversity, rules designed to encourage board diversity, they have nothing to do with those fundamental purposes.
With the foundational purpose of the SEC or the Exchange Act. Okay.
Exactly, and that's why the SEC acted beyond its authority when it approved the rule. That was the view of the majority.
All right, and so that was the opinion of the 9. What about the 8?
Well, this is interesting because the dissent was actually really different from the original panel opinion, the one that upheld the rule. And I think
So presumably, I'm sorry to interrupt. So presumably the 2 that approved on the limited, the 3 panel, were part of the 8.
Yeah.
And at the time they had this one, they had their one statement, but then they changed it when they were part of the 8 or something.
Yeah,
okay, go ahead.
Yeah, exactly. So it was a 3-panel opinion originally. I actually think only 2 of them were on the full court. I'd have to check because I think 2 of them were sitting. One was senior, and seniors aren't usually part of them.
Yeah,
They might have been. Well, I'm not sure, but whatever. It's definitely the panel was there, and the other Democrats were there, but there were a couple of Republicans as well, and they actually changed their reasoning. And I'm pretty sure that the reason they changed their reasoning was to hold on to those Republican votes. So they changed what they said because they adopted a tactic that was going to appeal more to the Republicans. So the dissent said their reasoning was, Nasdaq is a private company. It's a private company that sets its own rules for who gets to use its services in a competitive market with other exchanges. And Nasdaq decided it would be more competitive if it adopted this diversity rule. And the SEC, as a government regulator, is supposed to have a very limited role here. It's required to approve Nasdaq's own rules as long as they're consistent with the Exchange Act. So the view of the dissent, this dissent, the one that included Republicans, was very much like, why would you tell a regulator they should be more involved with a private company? That's ridiculous. We don't do that.
Oh, that's totally against your principles of regulation
But that's not how the original panel opinion wrote it. And this is why I think, I think it was adjusted to, for the Republicans. So the original panel opinion, the one that was written by Democratic judges, that one said, unlike the Fifth Circuit, the en banc Fifth Circuit, that the securities laws are about more than fraud prevention. They're about full disclosure. They're about
There's a whole disclosure.
Exactly.
That's related to, but apart from fraud.
Exactly. They're about full disclosure. They're about making sure that investors have all the information they need to make decisions to compare companies. And here there's lots of evidence that a wide range of investors want this information, so courts should just defer to the Nasdaq and the SEC's judgment.
In its capacity as a private company.
Well, it definitely is in capacity of a private company, but the original panel opinion was much more of this, but this isn't inconsistent with the SEC's purpose because the whole point is full disclosure. Disclosure is why we have the Exchange Act, and this is part of that, part of that.
Right.
But the dissent was much more, once they heard it with Republican, then it was less about full disclosure and more about private company. Let's not interfere with this private company making private company decisions.
So there's an interesting little element to this that sort of sheds light on the politics of judicial opinion making.
Oh, yeah.
When you get a group of 15 and you sort of see the who's going to be part of your age, just to use this particular one, what you and we've kind of known, I've heard, I don't study the Supreme Court at all, but that when there's groups of judges like this, there's a little bit of horse trading that goes on.
Well, sometimes, there can be bargaining and arguments about exactly how the opinion writes. Actually, I should check and see who actually wrote the dissent because I don't remember. But it seems to me fairly obviously a different bent, and there's a reason for it because Republicans were part of that group, and this was something they could all agree on. And I know that not just the parties there were a lot of amicus briefs filed, a lot of them, and some of them in favor of upholding the rule really focused on the private company status of Nasdaq because they knew that they were trying to appeal to these Republican judges who would find that argument more attractive. So
this is getting way beyond what you think of diverse boards.
No, this is much more than
and what the purpose of the SEC, or at least of the Exchange Act that created the SEC.
Yeah, I think this is a much bigger issue than diverse boards, and that's kind of why the opinion worries me. So I'll start by saying you said worries you, and this, and really I want to hear about that. All right, go ahead. Yeah, I'm not terribly sympathetic to the argument that this is just a private company doing private company things. I mean, one of the more hilarious things about the exchanges is whenever you try to sue them, they argue that they're completely immune because they're performing a regulatory function. And then if you say, oh, well, if you're a regulator, I'm going to sue you for violating the Constitution, they say, Constitution, we're just private companies. We're not bound by the Constitution.
Right.
I mean, while all this was going on, in a completely different case, Nasdaq delisted a SPAC for not complying with the listing rules. And the SPAC sued, claiming that the Nasdaq's actions were arbitrary and capricious. And what did Nasdaq say? It said that when it implements its listing rules, it's acting as a regulator and therefore is immune from private lawsuits.
Oh, interesting.
So the Nasdaq has this, like, all of these, like, arguments about, like, you know, as if you're trying to sue them, they're either a regulator or not a regulator, according to whatever they want to get out of the lawsuit about. So, I mean, I'm not terribly sympathetic to Nasdaq as just a private company.
Right, because the Nasdaq, when it's convenient, doesn't think it's a private company.
Exactly. It's a regulator when it wants to be a regulator. It's a private company when it doesn't want to be a regulator, and I just don't buy it. But that said, I'm really terrified by the Fifth Circuit's approach because the purpose, as you said, the purposes of the Exchange Act are much, much broader than simply preventing fraud. So one really big purpose of the Exchange Act was to regulate proxy voting. The Fifth Circuit acknowledged in its opinion that there are proxy voting parts of the law, but it kind of hand-waved them as not really that important, and that's wrong. Congress was very concerned about abuse of the proxy machinery in 1934, and in particular, Congress was concerned about self-perpetuating boards that would control vast corporations without concern for investors. I mean, this was progressive era legislation. FDR was out there making speeches about reining in princes of property, making sure that shareholders could vote and could actually assert control over corporate managers. That was a very big deal then.
That was yes.
And the Fifth
then
Circuit
it was a foreign concept. It was right.
And the Fifth Circuit was kind of like, proxy voting, that doesn't matter. But even more fundamentally, and we talked about this when we talked about climate change disclosures on an earlier podcast, I think most people today would say the main purpose of the securities laws is to make companies disclose information so that investors can set an appropriate price. It's not
valuation.
That's
what I do.
Exactly. It's not just about preventing fraud. We want investors to have information so they can efficiently price securities. And the reason we want that is because we want to make sure that capital is allocated efficiently. We want to make good, productive businesses get money, and we want bad businesses that are not productive to not get money.
And that's how I decide about where to allocate capital.
Exactly. So, you're just seeking a return on your investment, and that's fine. But by doing so, you allocate resources appropriately throughout the economy. It's how we grow our economy. It's how we put resources to their best use. And that requires a lot more disclosure than simply what's necessary for fraud prevention. But the Fifth Circuit, I think, went out of its way to signal, it's planning to seriously cut back on what it thinks the SEC is authorized to do. I think this was really a first step. It was like a sort of shot across the bow to start reining in the SEC across the board. And that could have some pretty dramatic implications
that's a big
for
deal.
everything the SEC does, not just the hot button issues like diversity and climate change.
Wow. So right now we have a Fifth Circuit opinion.
But I don't think anyone's going to appeal it. I mean, the SEC is not going to appeal it under the Trump administration, and Nasdaq, I think, has said it's not going to appeal it. I think. I just
so
don't
this is not going to
the
Supreme Court. We don't think.
No, I think it's probably over.
Ooh.
But we're just sitting out there with this, what I think this, so ominous Fifth Circuit opinion. That's like, okay, what are you going to do next?
Right. How else are they going to rein in the SEC? Oh boy.
Exactly.
Well, that's a lot to think about or even worry about, I suppose. Because I mean, again, I've said before, as much as I complain about, how they handle no action letters and so forth, I kind of like the SEC. As an investor, I like the protection.
Yeah, exactly.
So, all right, let's pause. How about that? Take a quick break, and we will return more to talk about ISS and Glass Lewis here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin. Mike, you encountered an interesting side of proxy advisors ISS and Glass Lewis about how they consult with corporations instead of when they consult with investors. So what exactly do they do?
Well, we all, or at least investors and companies, are intimately familiar with ISS and Glass Lewis. They're these proxy advisors that their fundamental job is to tell shareholders how to vote when they have dozens and hundreds of companies that have all sorts of issues to vote on. They write reports and analyze proxy statements and say, okay, vote for these directors or vote for this proposal and so on and so forth. We don't have to cover that. And you actually, what reminded me of this, which I'd written about 2-3 months ago, was how when we were talking a little while ago about what might happen in 2025.
Oh, yeah. Yeah.
Is how we speculate that there might be significant clampdown on what ISS and Glass Lewis does in a new presidential administration. And I kind of think this area of advising corporations will be possibly a big subject of what they do. Now, I need to say a couple things right away. At least for my part, I am generally an enthusiastic supporter of the proxy advisors, kind of a fan. I think they provide a valuable service. I think they're generally, pretty dispassionate. In my area of proxy contests, they tend to be as frustrating as they are helpful. But overall, they provide a good service. Okay. So this is all motivated, in fact, by something that I saw when I was looking at some other subject about director qualifications and how Glass Lewis, in fact, tries to solicit support from directors. And I kind of wonder why Glass Lewis is doing that. And as it turns out, Glass Lewis and ISS both have these businesses or these sections of their business that serve corporations very specifically. So we got kind of curious about that, and I did a whole bunch of looking into what they do and how they serve them, and it was pretty interesting. So there's sort of two areas of service that they provide to corporations, to boards of directors. The first is just reams of data and analysis about proxy votes and executive comp and so forth, just tons of data. So basically the same kind of data that they use and provide to their investor clients, they make available in various ways to corporations. Mm-hmm. But then the second gets a little more interesting, which is some advice about how to interpret and work with that data and analysis. So ostensibly, it's so that a given corporate client can improve corporate governance and so forth, and say, okay, this is kind of how people have voted and what people think, and this is how we can make our exec comp program better and more responsive, or at least how to improve the scores. Yeah. The ratings so you can see, that ISS and Glass Lewis generate.
You see why politicians are suspicious. It looks a little bit like a protection racket.
Oh, absolutely. There's all sorts of potential for conflicts and so forth, and compromise and so on. That's really interesting and worth exploring, and that's what we can talk about for a minute. So ISS has a completely separate business entity called ISS Corporate, that's where they kind of house these services. Glass Lewis isn't quite as distinct about how they do it, at least based on what you could sort of get from public information. Now, everything I was able to find out was just from reading and research. I didn't go interview anybody, though I have friends at both places, so I'm a little familiar with kind of how these businesses work. And anyway, so there's really 4 areas of these analytics, and 2 are more important than the other 2. The 2 that are less important is cyber risk and sustainability. Sustainability being the E of ESG, and investors are kind of curious or concerned about how a given company handles cyber risk and how well they're protecting themselves, and same thing, what are they doing to create a more sustainable corporation, and so on and so forth. So again, in the same way that ISS and Glass Lewis will help investors try to understand how a company is doing here, they're also going to sort of reflect back and help a company understand, what do investors think of your cyber risk and sustainability programs? Anyway, but those are less important. The two more important ones are corporate governance analytics and also executive comp analytics, particularly the executive comp analytics. As you can imagine, that's of keen interest to boards and CEOs. And so what ISS started doing and Glass Lewis followed quickly was actually, I thought, pretty clever, pretty resourceful. Okay, for Corp Gov and Exec Comp, they'd take these reams and reams of data, do the analytics, and the same kind of reports, the same kind of scores that they would then provide to investor clients. It could be pension funds, it could be it could be BlackRock, State Street, and Vanguard, all sorts of smaller funds, institutions, all their investor clients. They get all this analysis that helps them formulate voting recommendations, or in fact just recommends how to vote. They basically just kind of repackaged it and said, here's how corporations can use the same data. Now, in fairness, those two businesses, as far as I can tell, are much smaller than the core investor-oriented businesses. There's many fewer people work there and so forth, and they try to sell these consulting services to corporations in the same way, but it's just not nearly on the same scale. But nonetheless, they kind of exist. It was just basically a repackaging exercise that worked pretty well. So now it's worth noting that there's sort of three thrusts of the consulting business. Is they basically say, well, first here's the score we expect you're going to receive, and now that's where again these potential conflicts come up, and we'll address that in a little while. And then they also advise, and they'll say, okay, based on our experience with shareholders, and we advise them all, here's how we think shareholders are going to vote on your exec comp and corporate governance.
Well, here's how we think. That also, I think, is where the conflicts are. They'll vote as the way we tell them to. How do you think we're going to tell them?
Or how we can influence them. Right, exactly. Or if we, and then finally is importantly the real consulting, the real advisory is how a company can, improve its corporate governance, exec comp, or at least improve the scores. What changes should they make in the comp structure, in their bylaws, and so forth that will improve how they think about it. Now, these consulting services, ISS is very well established in consulting on Corp Gov and Exec Comp, and Glass Lewis, I think, does this more in Exec Comp than in corporate governance. It's not clear how they charge for this, what the fees are. Do you have a separate consulting project, or is it part of your subscription? Because most of these work, at least at its basic level, as a subscription service. Just like for investors, it's basically ISS and Glass Lewis are a subscription service. You pay some 5-figure number to get reports and so forth. Same thing for companies, and so it's not clear whether all this additional consulting is part of your subscription, whether you pay additional fees and so forth. I would expect that there's additional fee-based consulting. Couple other quick comments about it, which are kind of interesting, and then we can talk about the conflicts. Is ISS has, again, because they've been doing it longer, really tailors their services somewhat well. So, for example, they have a whole separate, little part of ISS corporate that works with law firms and work with comp consultants and so forth. So your comp consultant can, if you're a board, can contract through you to get the ISS analysis and sort of work it into their advice. ISS also has a really interesting, fascinating business. I didn't realize this until recently. They acquired an EVA. EVA is economic value added, which was this really cool way of looking at capital invested in a business and some really neat metrics. And a guy I knew at one point, Bennett Stewart, had created this this business. He was one of the founders of something called Stern Stewart, which 20 plus years ago was the pioneer of this EVA system. Anyway, I didn't realize this. ISS now owns EVA, owns the trademark and so forth.
So what does it EVA do? Because I've never heard of this.
EVA is a consulting business that ostensibly helps corporations to try to create better metrics for budgeting, for capital allocation. It's a whole system.
It's not even just like for shareholder voting. It's like,
here's how I can
EVA
run
myself
is a whole,
better.
Right. It's a whole different way to look at internal metrics for measuring a business. It purports to get away from pure accounting measures, and also allows businesses to understand the true cost of capital. Anyway, it was really revolutionary, and it's done pretty well since then. Though it never took off, I don't think, the way that Stern and Stewart really envisioned. And then, of course, ISS kind of bought them, which was kind of interesting. Anyway, so ISS owns them, and that's part, and it's part of ISS corporate. So anyway, so they really have this fairly sophisticated set of services, both ISS and Glass Lewis, that they provide to corporations. And that, of course, has led to all these, worries and fears. Is there a way to compromise that? Mm-hmm. Is there a way that a corporation can say, all right, can I buy everything that you sell?
And then you'll give me, and then you'll recommend that shareholders vote in favor of my comp.
And then you'll be my friend.
Yeah.
And that's a legitimate fear. And there's all sorts of potential conflicts. Could you just with this? Can we have a chance to talk to the researchers, and so forth, or whatever? Anyway, so there's been a huge debate about how this affects the kind of advice that ISS and Glass Lewis renders to shareholders. And after looking at it, I'm, at least as a shareholder, I'm not a subscriber. I'm too small. I make my own voting decisions. But as a shareholder, someone who's a representative of shareholder thinking, I'm pretty comfortable with how they deal with their conflicts. So first, as I mentioned a minute ago, ISS is a completely separate entity for this. And there are walls that I'm aware of between ISS corporate and the central ISS business that are fairly thick and fairly high. And the limits on their ability to talk between them are pretty considerable. And the penalties for violating those are pretty serious.
Okay.
It's not clear. And that extends to having their own offices, own employees, own leadership, everything. Mm-hmm. So there's really a lot of separation between the two businesses. It's not clear how separate Glass Lewis does this, though they do have a newer entity that dates back 2 or 3 years, I think 2021, where it's called Glass Lewis Corporate, similar to ISS Corporate, I guess, where at least the exec comp consulting sits within Glass Lewis. So I think Glass Lewis has segregated the exec comp consulting that way. So at least on paper, there's that kind of separation. There's also all sorts of codes of conduct that they've been very public about. ISS has a formal one that's a document that applies to ISS and ISS corporate that's sets forth these rules. Glass Lewis has a similar one. So they've sort of publicly said, here's our standards for this. It's also worth noting that ISS, the whole company, has registered with the SEC as a registered investment.
Yeah, that's come up with some of their proxy recommendations in general.
Exactly. So they have voluntarily subjected themselves to SEC supervision and regulation, presumably every so often they get an SEC inspection and so forth. That also helps to assure at least shareholder clients that this corporate business won't necessarily compromise their advice to shareholders and their voting recommendations.
Yeah, no,
so it's pretty cool.
I think the walls, they claim, and you could, I don't know if you know, like they might claim that when they make their voting recommendations, the people who do that don't even know who the consulting clients are. Or are they trying to?
Yes, yes.
So right.
That's
so
part
like
of the
I make a voting recommendation, but I don't even know if this company is using the consulting service. So I can't possibly favor or disfavor based on that.
Correct. The client, and that's, I mean, like all good consulting firms, the ISS corporate consulting list is pretty proprietary. Okay. But it is especially, and that much, that's a good point. That much that the client list is especially proprietary from everybody but like the most senior executives at ISS, holding company or whatever. So when you're doing a sort of the basic ESG shareholder proposal analysis, which is really the bulk of ISS's work and board recommendations, none of these people, and particularly when the special situation team gets involved, that's the one that focuses on proxy contests and so forth. They absolutely do not know.
Special situation?
Special situations.
Oh,
yes.
Gosh.
So that's
very exciting.
Oh yeah, no, they have that's kind of that's where at ISS that's really where the action is. The special sit. They for sure don't know who the ISS corporate clients are. And again, it's not a huge business,
right?
But it's one that's gotten a lot of scrutiny. There have been regular hearings and meetings and so forth at the SEC about how this works. I remember one a few years ago that I wrote a fun piece about. This is when I was blogging years ago about how the SEC tends to focus on this, and the SEC has so much other bigger things to work on, especially now like crypto and so forth. But it still will probably get some further attention this year, and I'm guessing that if the SEC decides to make life hard for ISS and Glass Lewis, I could see a situation where they might really focus on these these services for corporations and really try to cut them off.
Yeah,
so I don't know.
That's been proposed. There's been proposals to do more burdensome disclosure about the conflicts, as well as more disclosure about how they reach their voting recommendations, more liability, for that kind of thing.
And that's really unfortunate because at its core, I view ISS related to either corporate services, which we've been talking about, or the basic services for shareholders. It's a consulting business. It's a private consulting business. There is some argument that they're rendering some sort of investment advice that deserves some regulation in that sense. But the problem is that they kind of get under the skin of companies.
That's exactly.
And companies, companies can't they don't go after a sell side analyst when they slap it. I mean, they do, but there's nothing. They can't do anything to the guy's securities license for for slapping a sell on the stock. And so the SEC would probably be wise, and they have, to view it in the same spirit. So anyway, so that's ISS and Glass Lewis. We'll sort of see what happens this year. I think you're right to point out that maybe this will be a source of consternation and action for the new SEC commissioner in the coming year.
Okay.
So all right, I think we've covered all this in plenty of detail today. So we can maybe move on. How's that sound?
Okay.
All right, let's wrap up. It's been terrific talking to you, Ann, about these two fun subjects, and we'll have more to discuss in the coming weeks. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations, and is the Michael M. Fleischman Professor in Business Law and Entrepreneurship at Tulane Law School and an affiliate of Tulane's Murphy Institute. You can find me, Mike, at theactivistinvestor.com and Ann at law.tulane.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening, and we will talk again.